Thank you everyone for joining us this morning. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC, and today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So, whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few resources for the benefit of all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will send you a visa guide, which is a comprehensive guide that you can use as a resource regarding the visa types that will be introduced today. We will also send you a link that you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we regularly upload a variety of immigration-related videos that can be helpful to you. Finally, we'll also send you a link that you can follow to set up a consultation should you wish to discuss your case further with one of our attorneys. Today, we're very lucky to have Katie Perez, who is a senior associate at Scott Legal, who is actually a former USCIS adjudicator who adjudicated numerous O-1 cases. Katie has a wealth of experience handling cases in all of the visa categories that we'll be speaking about today, and we'll be presenting about the various options available to extraordinary ability individuals and the requirements and considerations. And I will also be your panelist. Finally, for any question you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started.
All right, thank you so much, Jay. Okay, so first let's start with discussing what are the extraordinary ability visa categories. The first ones we have here listed are the O-1A and the O-1B, which are both temporary non-immigrant visas. With these visas, you have the ability to work in the U.S., but you intend to come here temporarily to fulfill that work. In contrast, the green card option would be for someone who intends to work and live in the U.S. permanently. So again, the O-1A is a temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. This category has a very high standard in which you have to be one of a small percentage who's risen to the top of your field in your profession. Under the O-1B, this is again a temporary non-immigrant visa for people with extraordinary ability, but particularly in the arts. So O-1Bs are treated a little bit differently than the O-1A. The standard is slightly lower, and the person must have received distinction, meaning a high level of achievement, evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O-1B, you also have a separate category for people with extraordinary ability in the motion picture or television industry. The standard for the motion picture and television industry is a little bit higher. You do have to show that you have a record of extraordinary achievement in the motion picture and television industry, such that you have a very high level of accomplishment, evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, or leading in the field. So this is really in relation to your peers within the industry. So we'll go ahead and now discuss a little bit about the green card options for people with extraordinary ability. First, we have the EB-1A. This is very similar to the requirements for the O-1A and the O-1B, what that looks like. But there's not a separate category for the arts. So this category is all it's the extraordinary ability in the sciences, arts, education, business, or athletics, and it's all under one umbrella for that EB-1A. So the individual must be one who is a small percentage who's risen to the very top of their field of endeavor. And you have to show that you've sustained the national, international acclaim and that your achievements have been recognized in your field of expertise. So importantly, it is important to note that this person needs to be coming to the U.S. to continue to work in that area of extraordinary ability. So if you're someone who's had a very successful career and you're just looking to retire and you want to come to the U.S. For a green card, the EB-1A would not really be something that would work for you. The government would want to see a statement of your proposed intent, what you plan to do in the U.S., and it does need to be related to your field of extraordinary ability. So we also have the EB-2, the National Interest Waiver green card. This one's not always lumped in directly with the extraordinary ability visas, but it is a good option for people who maybe were on the O-1B and don't quite meet the EB-1A standards yet, but you still have a very impressive background and you're working on an endeavor in the U.S. that has substantial merit or national importance. So you may be eligible for the employment-based second preference visa if you are a member of the professions holding an advanced degree or its equivalent. You have a bachelor's degree with 5 years of progressive work experience, or you're a person with the exceptional ability. So these are the basic threshold requirements. If you're claiming the exceptional ability, you need to explain how your area of exceptional ability does relate to your proposed endeavor. The term endeavor is more specific than just your general occupation. You should offer details about your project, what you're going to do, and it should be above or more than just, the duties of that occupation. So, for example, if you're an engineer, your endeavor should really describe the projects you plan to work on, your goals, what you'll do as an engineer versus the basic duties of an engineer. You'd also need to provide a detailed description explaining that proposed endeavor, provide the supporting documents as evidence to establish that your endeavor is of national importance and has that substantial merit. You'd also need to show that you are an individual that is well positioned to advance this particular endeavor. So there needs to be kind of a nexus between your expertise and what you're going to be working on. And then based on that, you would need to show that it would be beneficial to the U.S. to waive the normal labor certification process that requires a U.S. employer and a labor market test, and that you should not have to go through that because what you're working on is so important that it is beneficial to have you here in the United States. So one very important thing about the EB-1A and the EB-2 National Interest Waiver is that you can self-petition. Um, this is more flexible in some ways with these petitions because you don't need to have a U.S. employer, which is not the case for many other green card categories and is not the case for the O-1B or the O-1A. For those temporary visas, you will need to either have a U.S. employer, the U.S. agent, or an agent operating for the foreign employer. Okay, so we'll discuss a little bit just about the specific requirements for the O-1A visa. So for the O-1A visa, you would need to demonstrate that you have a major internationally recognized award, kind of like the Nobel Peace Prize or a Pulitzer. However, much more commonly, people are going to qualify on the basis of showing that they meet at least 3 out of the following criteria. So 3 is the minimum. If possible, you would want to demonstrate to the government that you qualify with more, but 3 is the minimum. So first we have the receipt of nationally or internationally recognized prizes or awards. So here you would want to consider within the award, is it national, the whole nation, is it international, more than one country? A prize is something offered or striven for in competitions, contests. An award is often conferred or bestowed, especially based on the merit. So things to consider would be the criteria for winning the prize, past honorees, the number of prizes or awards given each year, limitations or on the eligible competitors, that sort of thing. So you really do want to consider the type of award. Was this something you won as a student? Is it something given by your university or your college? If so, that may not be as compelling for the visa. Um, so you want to look at it holistically, whether or not you're offering this piece of evidence and does it really strengthen your petition or would it kind of weaken the petition, your overall profile? So including things that may be like a student award you won at a university may actually lower your profile in the eyes of the government versus strengthening the petition. But in contrast, if you were at a university and you won a very prestigious award where other professionals in the field were also competing, You could and would want to include this award in the petition because it may show that you have really risen to the top of your fields. So we also have membership and associations in your field which require outstanding achievements. So here you would want a membership that actually requires you to have some outstanding achievement in order to be invited to be a member. So it is important to look at what are the requirements for entry. Can anybody enter? Does it actually require these outstanding achievements that you're claiming? Factors that you might want to consider, or factors that may suggest it's not really does not require outstanding achievements, is um, maybe the level of education. Is it based on a fee? For example, a lawyer has to pay a fee to join the bar association, but this doesn't necessarily show outstanding achievement. So anyone who passes the bar can pay a fee. So it doesn't require that outstanding achievement to be a member of the bar. So we also have published materials in professional or major trade publications or major media about you or about your work or something that you're working on. So this really should be about you, but the publication can cover a broader topic, include a substantial discussion on your work, but it should ideally mention you in connection to the work. The government will really focus heavily on whether the article is about you. So you do really need to make that connection for them. We also have original scientific, scholarly, or business-related contributions of major significance in the field. So an original contribution can include patents, processes, something like that. It is important to show how the work has already impacted the field. The potential impact is not sufficient in this criteria, and oftentimes people will provide something claiming, it will impact the field. Um, Oftentimes, as an adjudicator, I also saw people, they would provide testimonials talking about the work, the potential impact of the work, but this really is not sufficient. Ideally, you do want to show that the work, the original contribution has already impacted the field in a major way. So we also have authorship of scholarly articles in professional journals or major media in the field. This can include publications in professionally relevant journals or published conference presentations at nationally or internationally recognized conferences. This criteria often applies to those who are involved in academics, but it could apply to other fields as well. We have a high salary or other remuneration for services as evidenced by contracts or other reliable evidence. Here you're going to be looking at, what is your field, your occupation, where are you working, and are you really earning a high salary in comparison to others in your field, in your area? So you can show this by comparing your salary to labor statistics, but make sure you compare those apples to apples is what I always say. So if you're going to give an hourly wage, make sure you compare it to an hourly wage, not the annual wage. Okay, we also have participation on a panel or individually as a judge of the work of others. So you must show that you've participated as a judge of the work of others in your same or allied fields. An example of this could include reviewing abstracts or papers submitted for presentation at scholarly conferences or serving as a peer reviewer for these scholarly publications. You might document your peer review work by submitting a copy of a request from the journal for the review, accompanied by evidence confirming, that you actually completed that review. A lot of times this could just be an email or something like that. We also have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would want to explain your role within the organization with sufficient detail, explaining how it was critical or essential. Critical is, you've contributed in some way that is of significant importance to this organization. Essential was your role integral to the entity. So a leadership role in the organization often qualifies as that critical or essential role. You do also need to show that the organization is distinguished. So if you were a CEO of a very, very small company, you could likely show that you had a critical or essential role, but maybe the company's not distinguished. That might be harder to show. Conversely, if you work for a really big company like Apple, it's very well known. It's easy to say it's distinguished, but if you're working in the factory boxing up the phones, it would be difficult to really show that your role is essential. So this part kind of this criteria kind of has two elements to it. Okay, so we'll go on to O1B. So what do you need to demonstrate for the O1B? Again, so this category is for the arts and those in the motion picture television industry. The O1B does have a similar structure to the O1A in the sense that you're going to qualify by a significant award that you've won, like the Grammy or an Oscar, or you're going to demonstrate that you satisfy at least three out of the following criteria. So the first criteria is that you have been and will perform as a lead or starring participant in a production or event with a distinguished reputation. Evidence could include, that you've served as a principal role in an event or production. A starring role often means a position of great prominence relative to others within the production or event. So, you want to consider, were you in the background scenes or were you really participating as a principal role? Generally, the difficulty with this criteria is showing that future element. So this one does also have kind of two elements within one criteria. You have to show you already served as a leader starting role, but also you need to show that you will in the future as well. So it can be hard to show that future element, showing that the future productions have this distinguished reputation because you may not have evidence like critical reviews or advertisements yet. We also have critical reviews or other published materials in professional or major media by or about the beneficiary. So here, the difficulty can also can come with showing whether or not that media is major. That was often when I saw people had trouble showing that part. The government doesn't hold much weight to self-published articles or articles that are not vetted versus, an article in the New York Times, which is easy to show that it's a big newspaper that lots of people read it. So let's see. The next, we also have evidence that the beneficiary has performed and will perform in a lead or starring or critical role within the organization or establishment, and that establishment needs to have that distinguished reputation. So it is important to remember here that the critical role is for the organization. It's not just for the event or production like we discussed in the first criteria. So you do want to, for example, the first one you may have been a movie star, a leader starring role in a movie, but maybe this criteria you actually work for the production company. You work as the CEO of the movie studio, something like that. Um, you might want to show, really what your role is. Was it permanent or temporary? To kind of distinguish that you do qualify for this, that you have a critical or starring role within the organization versus just an event. We also have evidence of a record of major commercial or critically acclaimed successes in the performing arts. So this is shown by the box office receipts or record, cassette, compact disc, or video sales. This criteria does have some of the outdated evidence. People don't sell cassettes anymore or records or CDs probably in most areas. So you may have to be more creative. So for example, with that commercial success, you may not have those record sales, but you may be on YouTube. And if you're on YouTube, do you earn money? How much? Can you really show this commercial success monetarily from your YouTube channel? Something like that. So if you are demonstrating this critically acclaimed success, the evidence should demonstrate that your work has received the public-facing praise or positive reviews in the relevant field. So, okay. We also have evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in the field. This can be in the form of a testimonial, and it is really a common piece of evidence. I think most people submit with their O1B petitions, but you should really make sure that your testimonial is, beneficial to the petition. Is it really supporting it? So this testimonial should really include a description of your achievements. So if you're speaking to someone's potential, you're mentioning that they're just a hard worker, that will not be sufficient. You want to detail the achievements that are important, explain why they're important, and how maybe they amount to an achievement within the field. Again, we also have evidence that you have commanded a high salary or other significantly high remuneration for services in relation to others. So you can, again, show this by providing those labor statistics. And again, just make sure you're comparing accurately. If you're giving the hourly wage, you'd want to provide the hourly wage. So we also have, lastly, the other comparable evidence. So if you're applying for the O-1B in a very odd or niche field and you feel that the above criteria that we just discussed doesn't really apply to you, then you can demonstrate or try to demonstrate to the government that these do not apply to you and you need to explain why. And then also explain why the evidence you are providing is comparable. So this is actually kind of a big hurdle to meet. In all the years that I did adjudicate these, I don't think I saw one petition be able to satisfy the comparable evidence. That's not to say that it hasn't happened, and I had heard of examples where people were able to do that, but it's just not very common. And then just one other note on the comparable evidence that this category, you cannot provide the comparable evidence for those in the motion picture television industry. Okay, so we'll discuss just a few of the differences for the O-1B and the O-1A. Again, the O-1A is for the sciences, education, business, or athletics. The O-1B is for the arts and motion picture or television industry. The standard for the O-1A, again, is one of a small percentage who has risen to the very top of their field of endeavor. The arts, you have a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And then within the motion picture television, you have that level of acclaim substantially above that of the person's peers. So the O&A and the O&B can be issued for up to 3 years. It really does depend on the contracts, the employment contract that you have, what is the work you will be performing. You would want to provide this evidence to the government. So if you provide evidence that you have work for 1 year, then you would probably get a 1-year validity period. If you have work for 3 years, you could get up to 3 years. You are able to extend these petitions. You can extend up to 3 years if you, again, can show within your itinerary and contracts that you have work to be performed for another 3 years. Your family can also join you when you come for the O-1A and the O-1B. But if your spouse wants to work, they would not be able to work under this category. They would need to get a different type of visa. So just one other note quickly on the O-1A and the O-1B. The O-1A is the higher standard. So if you know you have a occupation that is somewhat fluid, maybe you can fit within the O-1B. You may want to consider fitting yourself into the O-1B category versus the O-1A just because the standard's a little bit lower. Okay, so we'll go on to the extraordinary ability EB-1A and what are the requirements. So this category is very similar to the O-1A and the O-1B. There's a little bit of difference within the language because it does incorporate the arts, sciences, education, business, and athletics all together. The structure, again, is very similar to the O-1A and the O-1B, where you can qualify with that major award. However, most people will qualify based on showing that they meet at least 3 out of the following criteria listed, or 3 out of 10, sorry, of the criteria listed in the regulations. These criteria are similar or some of the same to those that we already discussed in the previous slide. So I'll again run down them quickly, but I won't give the examples for them. So here for the EB-1A, you can provide evidence of a receipt of lesser nationally or internationally recognized prizes or awards for excellence. You can provide that evidence of your membership in associations in the field which demand outstanding achievements of their members, evidence of published material about you in professional or major trade publications or other major media, evidence that you have been asked to judge the work of others, not especially, either individually or on a panel, evidence that of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field, evidence of your authorship of scholarly articles in professional or major trade publications or other major media, evidence that your work has been displayed at artistic exhibitions or showcases, evidence that you have performed as a leader, critical role in distinguished organization, evidence that you've commanded that high salary, high remuneration, or evidence that you have had commercial success in the performing arts. So sorry, sorry quickly with the EB-1A, you do need to show that you're coming to work in that your area of extraordinary ability, and oh, that's fine. We'll go on to the next one. Sorry, GA. Thank you. Okay, so within the EB-1A, you do need to provide that you have earned this nationally recognized award, like we said with the Pulitzer, the Nobel, something like that, or provide evidence that you meet 3 out of the 10 criteria. However, simply meeting the 3 out of the 10 criteria won't just earn you the green card. You do need to meet this second step. So in the second step, the government will consider the quality of the evidence in totality. So they're going to make this final determination of whether or not you've risen to the very top of your field, whether you're a very small percentage of people who are very risen to the top of their field of expertise. So you do really need to look at your petition in totality. What is the evidence you're providing? If you throw everything at the government saying, you qualify, you've met every criteria listed, um, this may not satisfy for them. You really want to put your best foot forward, providing the best evidence so that once they look at the petition holistically, it does really show that you are someone who's risen to the top of your field. And then, so we do have in January, there was a federal district court in Nebraska that ruled that, USCIS's adoption of the Kazarian two-step, which is what I just discussed, showing that you've met the 3 out of 10, and then holistically that your petition, you've shown that you've risen to the very top of your field, was unlawful and reversed the denial based on that final merits determination test. So while this decision is not binding across the country, the reasoning does serve as persuasive authority for other courts and could result in policy changes within USCIS, and we will see how that plays out within them.
All right, thank you for sharing your expertise, Katie. And now I'll take over and introduce the EB-2 National Interest Waiver, which is not exactly an extraordinary ability visa category, but there can be a significant overlap with some of the profiles of clients who may qualify and consider also the NIW as an alternative, especially if maybe their profile is not as highly recognized as to rise to the EB-1A standard. All right, so let's look a little bit at what is the eligibility requirements for a green card under the EB-2 NIW category. So the first requirement to meet is the threshold requirement, which applies to both EB-2 perm cases with employer sponsorship or the national interest waiver cases. And keep in mind that the national interest waiver category, if you can show that you would qualify for the NIW, you are allowed to self-petition, which can be quite a significant advantage alongside the EB-1A, which also allows self-petitioning by the foreign national, does not require a sponsorship from a U.S. employer, does not require a job offer. So let's go through the EB-2 threshold requirement. You can meet the threshold requirement by either of the two pathways listed here. You can either show that you have an advanced degree, defined as a master's degree or higher, or the equivalent of an advanced degree, which you can meet by showing that you have a bachelor's degree in your field, plus 5 years of post-baccalaureate progressive work experience in the profession. Keep in mind that the degree and the work experience must all relate to the proposed endeavor that you're coming in to do in the United States. Now, when we are meeting the advanced degree professional threshold by showing a bachelor's degree plus 5 years of work experience, it is very important to note the word progressive that qualifies the work experience. What does progressive work experience mean, and how do you prove it? It is important to note that the government looks at whether your job duties and the nature of your responsibilities changed over time to involve more senior, more complex duties as time went on. As such, you want to be able to show an increasing trajectory of, the complexity and seniority of your work, as opposed to the job duties and your responsibilities staying the same over the 5-year period. So not only do you need to show 5 years of full-time work experience after you've earned your bachelor's, you need to also show that this job, the work experience was progressive. And in order to show that, you would need to get detailed letters, confirmation letters from your previous employers that would provide enough detail that can actually convince the USCIS officer that the job duties have had changed over time. Now, if you don't have a bachelor's degree or if you don't have the requisite years of experience, if you don't have a master's degree or above, there's another way to qualify under the EB-2 threshold, and that is by showing that you have exceptional ability in the sciences, arts, or business. And in order to show exceptional ability, it is important to note that this standard for exceptional ability is lower than the standard for extraordinary ability that we've been talking about in the EB-1A context. So whereas for the EB-1A, and we talked about this in previous slides, you need to show that you're one of the small percentage who have risen to the top of the field. For exceptional ability, you only need to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the field, which is definitely a lower standard to meet. And in order to substantiate this, you would want to show at least 3 out of the 7 evidentiary criteria listed here. For example, official academic record for any degree, even if it's not a bachelor's, even if it is not a master's, 10 years of full-time work experience in your profession, if you have a license to practice your profession, if you have evidence that you have commanded a high salary compared to others in your field, if you're a member of any professional association that's relevant to your field, and importantly, if you can show that you've received recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations. And many different types of evidences can come under this rubric. If you have earned awards in the industry, if you've been, reported in the media for the significance of your achievements, if you've received grants from government agencies with regards to your research projects, if you can get letters, expert letters from leaders in your field talking about your achievements and why they were significant, all of those types of evidences can be helpful in showing that you've received that recognition. So a variety of forms of evidence can help show that you have exceptional ability in the sciences, arts, or business, which can be an alternative way to meet the EB-2 threshold if you don't have the requisite degree or experience. Now, it is important to note that meeting the EB-2 threshold is only half of the picture. The other half of a successful EB-2 NIW application is to show that your case qualifies for an NIW. This is important because in the alternative, what the ordinary requirement is the labor certification requirement. Usually, someone who's qualifying for a green card under the EB-2 category would need to have a U.S. job offer. And you in your sponsor, the U.S. company, would need to go through a process of testing the U.S. labor market to see if there is anyone else in the United States who is minimally qualified who can take your job before being able to sponsor a foreign national for that particular position. But if you can show that your case merits an NIW, you're exempt from that requirement, which allows the foreign national to self-petition for a green card without a job offer, and also could, significantly reduce the time and effort it takes to get to the green card because the labor certification process is no longer required. So now let's go through the 3-prong matter of Danaher test for which you would need to prove and provide the evidence for in order to prove to the government that your case may merit a national interest waiver. The first prong is that the applicant must provide enough evidence that shows the proposed endeavor in the United States has both substantial merit and national importance. And let's talk a little bit in more detail about what that would mean. So to show that an endeavor has substantial merit and national importance. Substantial merit can be shown in a wide variety of fields. It can be in business, it can be in health, education, science, and technology. Um, and and endeavors that tend to further human knowledge in those key areas, such as for medical advances or improving manufacturing processes, those types of endeavors can be found to have substantial merit and national importance because they may impact the field and help advance that particular field. Now, a strong economic impact that can be expected from your endeavor, that can also be helpful in meeting the substantial merit and national importance prong. So really the question that you want to ask is, what is the future impact of what I am proposing to do in the United States, and how is that important to the United States? And what is very important to note, especially in recent years, is that simply working in an occupation is not considered an endeavor that rises to the level of national importance. Simply working as an engineer for Google, for example, even if the company is a large company, that would only tend to benefit the particular employer that uses your services. And if the benefit is only uh, for the private interests of one employer, the immediate employer that uses your services, unfortunately, the USCIS will find that such an endeavor would not rise to the level of national importance. So, really, talking about the impact to the field that can happen for the advancement of certain technologies, if you can prove that the results of your projects will be disseminated to others, if you're someone who, invents new technology, and if that technology is published as a patent, and if you can show that many different companies or many different researchers may want to cite to that patent or license that patent and use that particular intellectual property to enhance their own projects, those types of follow on impact to advance projects that are other than your particular employer's projects would be helpful in showing that the impact of your work goes beyond simply benefiting one company or your immediate clients. So definitely a lots of nuance and specification is very important in making a strong argument for substantial merit and national importance. Now, the other aspect of an NIW petition is showing that the applicant is well positioned to advance the proposed endeavor. And for that prong, the government really looks at the individual and what is the individual's previous experience, previous education, any record of success in prior projects that could indicate that this person will be well positioned to advance this endeavor that was found to be nationally important for the United States. So intellectual property can be helpful in meeting the well-positioned prong as well. If you have a track record of sharing the results of your research, for example, through patents or publications or conference presentations, that kind of industry impact and history of industry influence can be used to inform the government that you will have a similar impact in the United States if you come to the U.S. to propose to continue your endeavor. Any advancements that you've already made towards the endeavor. So if you are an entrepreneur, if you've made a startup and maybe you're already in the United States on an E-2 visa or maybe another immigration status, and you've already been running your company for a while, maybe you've secured influential contracts with industry leaders. Maybe you've, secured, a place in a prestigious incubator or an accelerator. Those types of track record that shows that the endeavor is on its way to be developed. That can also help prove that you're well positioned to advance the proposed endeavor. So a variety of evidences can be used to help meet that prong, but definitely there needs to be more than just a business plan to support that you would meet the NIW requirement. Finally, the third and last prong for the NIW matter of Danaher test is that there must be a showing that on balance, it must be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification for your particular case. And a variety of strategies can be used to successfully argue this prong. So you can rely on evidence from prong one, talk about the broad systemic effects that your work can have to the field as a whole, or benefits, large scale benefits that you can provide to the economy or society. You can also provide arguments regarding some of the evidence you use on prong two. So if you have unique know-how and if you have unique evidence and experience of successfully running similar projects that other US workers with minimum credentials simply wouldn't have, then you can use that as part of the balancing test on showing that maybe it would be beneficial to exempt the labor certification requirement for you because this particular unique expertise would be so valuable to the United States. Finally, for entrepreneurs, there can be special considerations you can point to. So, for example, if your project will bring substantial economic benefit to the United States, such as job creation or generation of tax revenues at a level that is significant with respect to the conditions of a particular region, and in comparison to the total population of that region, you can use those kinds of considerations to support your case. Similarly, you can point to the practical difficulties that an entrepreneur may have if they are trying to get a job offer from a different company, or if they're using their own company, and if they have majority ownership in that company, they're not able to avail of the green card petitioning process in the traditional way. So you may be able to point to those types of practical difficulties in support of the balancing test on whether an NIW would be appropriate in this particular circumstance. All right. Now let's shift gears a little bit and discuss about expert opinion letters, which are a very important element for all of the categories of visas that we were talking about. EB-1 petitions, O-1 petitions, and NIW petitions. Expert opinion letters play a very important role. So what is included in expert opinion letters and why are they important? How should we think about preparing them? For certain types of petitions, it is good to obtain expert letters from key individuals in the industry, and this can include past employers, your colleagues, clients, professors, Nobel Prize winners, etc. The function of the expert letters would be different on what element you're trying to prove in your particular case. So, for example, if you are preparing an EB-1A or O-1A case, you would want the experts to confirm that you have extraordinary ability in the field and is well known because of the significant contributions you've made in the industry before. So really the letters for extraordinary ability petitions for EB-1A and O-1 petitions would be past looking because you want to be able to show that you've already made a substantial, significant impact in your field, significant contribution in the field in your past experience. Now, for the NIW case, depending on which prong you're trying to prove, the purpose can be different. The content can look a little bit different. So, for example, if you're trying to prove the first prong, that your proposed endeavor has substantial merit and national importance, the impact argument is forward-looking. So you want to have the experts focus on the expected impacts of your work in the future in the United States and what can we expect from that particular project on how it can advance the status quo of the industry. And this is a little different from what we've been just talking about, where for the EB-1A and O-1, you want to convince the government that you've already made those significant contributions in your field. Now, for certain types of NIW letters, for example, if you're trying to prove that you're well positioned to advance the endeavor, then those types of letters would be past looking as well. So those types of letters supporting well positioned would look at your previous record of success and provide more detail about what you've done, how it influenced the industry, how did the how did you solve limitations that were pervasive in the industry, and how did the benefits of this work go beyond just benefiting your immediate employer or your immediate client? So those types of case studies can really be, brought in full view through, the letters that experts in your field who's familiar with your work can provide. Now, it is important to think about who is writing the letter. Usually, uh, with the letter, we would also provide a copy of the full-length curriculum vitae, the resume of the person who is writing the letter, just to provide, that level of credibility to USCIS, and that would make it more likely that USCIS would put more weight on the assessment that is given by that writer. Importantly, you want to have a mix of independent and inner circle letters. Different letters have different evidentiary strength depending on what you're talking about. So, if you are, for example, trying to prove that you've played a critical role in a particular organization, you want to get a letter directly from that organization that you work for, and the representative of that organization will provide a personal testimonial based on, what they know about your work and the importance of that work for that organization. And that would be a kind of an inner circle letter in which you would, get that letter from someone that you've directly worked with before. Now, in other contexts, you may want to get a letter from an independent expert who doesn't personally know you or doesn't personally have experience working directly with you, but nevertheless know of your work or know about the significance of your work through, just being a part of the industry and being an expert in that industry. So those types of independent experts can provide a more objective assessment of the impact of your work. For example, if you're trying to prove that you've made a significant contribution in your field, if you're trying to prove for an NIW that your future work will, have a broad impact to the area of endeavor, like those types of letters can be powerfully delivered by someone who hasn't worked with you in the past, but nevertheless is an expert in the field who can provide an objective opinion on that. With regards to the content of the expert letters, specificity and concreteness is very important. Now, USCIS will not tend to rely on conclusory or vague remarks that only, are a copy and paste of the language that is used in the regulations. If you use some AI tools, for example, to draft a letter, maybe, the language that they may use may mimic the language that is used in the regulations, but maybe the content is just simply not detailed or concrete enough to be persuasive to the USCIS that this is actually saying something real. So really, there is a proliferation of these do-it-yourself tools and a lot of AI programs that claim to help, generate contents for those letters for you. But really, we want to emphasize that caution would be recommended in using those tools because if the letter just tends to, contain language that sounds nice or that tends to mirror their regulatory criteria, but doesn't really have that real specific on the ground detail that only someone who's actually worked in that, field can talk about, then it will simply not be, evidentiarily helpful for USCIS, and USCIS would simply not rely on those letters. So definitely work with an experienced attorney who can really help you guide, what kind of content can be helpful and persuasive to the perspective of the officer who will be reading your case. All right, now let's shift gears a little bit and talk about the strategic considerations when you're, oscillating between thinking about EB-1, O-1, NIW categories, trying to decide which category to apply for. What are some of the considerations that can inform that decision? So the first question is to consider, do you want to stay in the United States temporarily or permanently? And as Katie went over in the previous slides, the O-1 visa categories are non-immigrant visas, well suited for individuals whose intents to come into the United States to work are temporary. Now, the EB-1A and EB-2 NIW are both green card options and really well suited for people who want to live and work in the United States permanently. And keep in mind, if you become a permanent resident of the United States, a green card holder, there are also responsibilities that attach to being a green card holder. And we won't really get into a lot of detail about this, but you may want to think about tax considerations, registering for a special service if you're, subject to that. So many different considerations. And also, there may be limitations on how long you can stay outside the United States at any given time if you are a permanent resident and if you want to maintain permanent residency. You should not be traveling for extended periods to the extent that can lead an officer to believe that you have abandoned U.S. permanent residence. So definitely strategic considerations that you want to think about on obtaining and maintaining permanent resident status. The other question you want to ask yourself is, do you have a U.S. employer agent or do you want to self-petition? The O-1 visa requires either a U.S. employer or a U.S. agent to file the petition. It cannot be a self-petition by the foreign national himself or herself. It is important to note that if you are an entrepreneur and if you create your own LLC or corporation, a legal entity in the United States, that legal entity will be considered a separate legal entity from yourself. So actually, even if you have ownership over the U.S. entity that you establish, that entity may be able to file an O-1 petition. Now, in those types of scenarios, it is very important to be able to prove to the government that this is not just a paper company, right? So there are particular additional evidences that you may want to consider adding, such as letters of intent or proof of capitalization or proof of, contracts proving that there is actual work lined up for this new entity that you form. But provided that you can provide the appropriate level of evidence, really it is possible for an entrepreneur to get an O-1 visa petitioned by a startup that they found in the United States, even if they have ownership over that startup. So that can be an option for some entrepreneurs. EB-1A and NIW are both green card options that allow the applicant to self-petition if they meet the requirements. So the foreign national themselves can be the one who drives forward the petition. That can be a great option, especially if you don't have that US connection. Family considerations. Let's talk about options for families. So as Katie mentioned in the previous slides, for the O-1 visa, your spouse and minor children under 21 can join you in the United States as O3 dependents. They can attend school while they're here in O3 status, but they cannot work. So your spouse would unfortunately not have work authorization with the O1, O3 status. For the EB-1A and NIW, this is a green card option. And if you obtain the green card under one of these categories, your spouse and children under 21 can also apply for green cards as your dependents and can also apply for the benefits such as work and travel authorization if you are choosing to file the I-485 to adjust status within the United States to a permanent resident. And if your dependents are also choosing that option, the associated benefits of an EAD and an advanced parole is also available for dependent applicants as well. Some other considerations we can go over when you're moving from a non-immigrant visa to a green card. The first element to note is that regarding qualifications for eligibility, there is a higher standard to qualify for the EB-1A as compared to the O-1A or O-1B visas, practically, even though the regulatory language is written in similar terms. Practically, the way that USCIS looks at each of these evidentiary criteria is much more strict in the EB-1A context, given that the EB-1A is that first priority green card, as opposed to adjudicating when adjudicating O-1 petitions, which are for temporary visa uses. So this just means practically that qualifying for an O-1A or O-1B does not mean that you automatically qualify for an EB-1A. Especially if you're trying to go from an O-1B to an EB-1A, that can be a particularly high jump because even the definition of extraordinary ability is different in the O-1B context as opposed to the EB-1A context. So when you are exploring transitioning from an O-1A, O-1B to EB-1A, definitely you may want to speak to an experienced attorney who is familiar with both types of petitions to really look at your profile, really look at the strength of the evidence for your profile, and see if there are any areas you can bolster before trying for the higher standard for the EB1A that will be beneficial to you. You may want to take a couple of years to further develop and strengthen your profile before applying. Timing is another consideration that can be important. Consider how much time is left on your current underlying visa, because some visas may be harder to extend or subject to more scrutiny once an I-140 is filed or a green card petition is filed. And some of the examples of such visas are the TN visa. The TN visa is a category that really looks strictly at non-immigrant intent. So once your I-140 is filed, you may encounter more scrutiny at the border when you are applying for the TN visa again. So in those types of cases, and definitely speak to your attorney with regards to, the specific risks in your circumstances, but you may depending on your circumstances, you may want to renew the TN visa first before pursuing, preparing and filing an I-140. So definitely some strategic considerations come into with regards to timing, especially if the underlying visa is non-dual intent. Now, certain types of visas are dual intent, the H-1B and L visas, for example, in which case those concerns would not apply. But for other types of visas, this would be a real consideration. Family considerations can also influence your decision on choosing when and how to apply for the green card. Because if you have children who may also need the green card, you may want to consider filing early to avoid issues with the child aging out at 21, at which point they will no longer be eligible for the green card. All right, so the final topic to address before going to the Q&A is, are extraordinary ability categories available for entrepreneurs? And the answer to this question is a resounding yes. For the EB1A and NIW, these categories both allow for self-petitioning, meaning that both are possible options for entrepreneurs. Secondly, there were changes in the NIW standards under the precedent case matter of Denisar since 2016, which made NIW a much friendlier category for entrepreneurs, and we have seen many approvals for entrepreneur petitions under the NIW category. Even though it is becoming more and more challenging, there are definitely arguments we can make, and we regularly guide clients on how to build their cases to have a good fighting chance of approval under the NIW standard. Finally, it is possible to apply for an O&A visa as an entrepreneur if you have a separate corporate entity as the petitioner in the United States that can act as the U.S. petitioner. Keep in mind that you may want to collect supplemental evidence to show that this is not just a paper company. We can provide further guidance if you reach out to us for a consultation. All right, so now let's see if there are any questions that came up. I don't think there is any. So what we will do now is close our presentation. Thank you, Katie, for sharing your valuable insights. I'm sure this was helpful for all participants.
Thank you, Jiyae.
All right, and hope you all have a wonderful day.
Bye.